If you're a personal injury lawyer representing a client for whom you applied for a catastrophic impairment designation in relation to a car accident that occurred on or after June 1st, 2016, for which your client was neither involved in nor witnessed, then the insurer probably responded by stating your client is not entitled to apply. Now, if you keep abreast of the new case law, then you might respond, how can that be? In the recent case, Kellerman-Bernard and Unica Insurance Company, the divisional court found that the applicant was eligible to make a claim for a catastrophic impairment designation, despite not being directly involved in the accident. Well, yes, that's true, but the accident in this case occurred before the June 1st, 2016 legislative changes. So this begs the question, is your client entitled to apply for a catastrophic impairment designation despite not personally having been involved in the accident that occurred on or after June 1st, 2016? Well, in a recent license appeal tribunal decision, the arbitrator answered yes. In this episode, I'll discuss the new LAT decision and much more. Stay tuned. And welcome to the 6th episode of Season 2 of my vlog, Personal Injury Lawyer Tips. My name is Leroy Rudder. I'm a personal injury lawyer specializing in catastrophic impairment law. I'm also a published author of the LexisNexis Inc. book called Catastrophic Impairment Law in Canada, a director at Head Injury Rehabilitation Ontario, a co-chair of the Law Society of Ontario's annual solo and small firm conference, and the founder and owner of my law firm, Rudder Law Group. In this vlog, I'll be discussing a recent license appeal tribunal decision entitled Ciasulo and Unica Insurance Inc., where adjudicator Kate Greaves found that the applicant was entitled to apply for a catastrophic impairment designation, despite not personally having been involved in the accident, which occurred after June 1st, 2016. So in episode 4 of my vlog, Personal Injury Lawyer Tips, I discussed whether or not a person not involved in an accident prior to June 1st, 2016 can meet the criteria for a catastrophic impairment as defined by the Ontario Regulation 34/10 Statutory Accident Benefit Schedule, or the SABS for short. If you haven't watched episode 4, then I strongly encourage you to do so by either visiting my YouTube channel with the handle @Rudder Law Group, or visit my vlog webpage on my website, RudderLawGroup.ca. In that vlog, I discuss a recent license appeal decision entitled Kellerman-Bernard and Unica Insurance Company, where the adjudicator initially rejected this notion. I then take a deep dive into the divisional court's decision to overturn the LAT's decision and ultimately rule in favor of a person not directly involved in an accident to apply for and meet the criteria for a catastrophic impairment designation. So if you want to apply for a catastrophic impairment designation on behalf of your client who was not directly involved in an accident that occurred on or after June 1st, 2016, and you rely on this divisional court decision, then the adjuster on your file will likely not be persuaded by it. The adjuster will likely advise you that they are aware of the divisional court decision Kellerman-Bernard and Unica Insurance Company, but that the decision deals with a pre-June 1st, 2016 date of loss. And as such, they believe that the change in the language of the CAT definition in Section 3.11 of the SABS does restrict CAT determinations from those who were not directly involved in an accident. Well, this begs the question, What change in the language of the CAT definition under Section 3.11 are they talking about? In the Kellerman-Bernard and Unica Insurance Company case, the accident took place on January 26, 2016. So the version of the SABs for the period August 26, 2015 to March 3, 2016 applied, where Section 3.2 of the SABs defines catastrophic impairment as follows, quote, "For the purposes of this regulation, catastrophic impairment caused by an accident is," end quote, and then followed by a list of 6 categories of physical, brain, mental, and behavioral impairments. However, in the current version of the SAB, Section 3.11 defines catastrophic impairment as follows, quote, "For the purposes of this regulation, an impairment is a catastrophic impairment if an insured person sustains the impairment in an accident that occurs on or after June 1st, 2016, end quote. It then goes on to list the functional and medical criteria for a catastrophic designation applicable to an insured person who was injured in an accident that occurred on or after June 1st, 2016. So what emerges from an attempt to apply the aforementioned divisional court decision in Kellerman-Bernard and Unica Insurance Company to a factually similar case involving an accident that occurred on or after June 1st, 2016, is an interpretation issue of serious contention due to the change in the language of Section 3.11 from "as a result of an accident" pre-June 1st, 2016 to "in an accident" post-June 1st, 2016. Furthermore, the insurance adjuster on your file will take the adamant stance that your client is not entitled to apply for a catastrophic impairment designation because your client was not involved in the accident, and thus your client did not sustain injuries in the accident. The insurer will argue that the aforementioned change in the language of the section indicates clear legislative intent to restrict entitlement to apply for catastrophic injuries to those insured persons who were actually involved in an accident, where they'll emphasize that the phrase "in an accident" does not appear elsewhere in the SABs aside from the definition of an insured in Section 3.1. Lastly, they'll emphasize that throughout the SABs, the broader phrase "as a result of an accident" is used when addressing entitlement to other benefits. This is what Unica argued in the aforementioned case, Ciasulo and Unica Insurance, Inc. So if you're plaintiff counsel, then what can you argue in response? In the same case where Michelle Michael Ciasulo, the applicant, applied for accident benefits to Unica Insurance, Inc. as a result of a motor vehicle accident which occurred on June 18, 2020, involving his wife and children who tragically passed away. His counsel put forth compelling arguments. They addressed the interpretation issue regarding the change in the language by arguing that the phrase "in an accident that occurred on or after June 1st, 2016 was simply to differentiate the criteria applicable to accidents that occurred before June 1st, 2016. And the word "in" does not require that the applicant be physically involved in a collision in order to apply for catastrophic impairment. Furthermore, they argue that the addition of the date in the section is only used to identify a time frame by when the functional and medical criteria for a catastrophic impairment designation was changed, but did not create a restriction to insured persons when read in the entire context. Lastly, they argue that if there is any disconnect between Section 3.1 and Section 45.1, it should be read in favor of the insured. The adjudicator in this case sided with the applicant and again found that he was entitled to apply for a catastrophic impairment designation, despite not personally having been involved in the accident nor witnessing the accident. The reasons the adjudicator provided are informative. Similar to the aforementioned case Kellerman-Bernard and Unica Insurance Company, where a divisional court considered the statutory interpretation of the pre-June 1st, 2016 version of the SABs and a definition as it was in Section 3.2. The case Ciasulo and Unica Insurance, Inc. also involved the interplay between 3 provisions of the SABs, which are as follows. 1. Section 3.1, which defines who is an insured person. 2. Section 45.1, which provides that an insured person is entitled to apply for a catastrophic impairment designation. And 3. Section 3.11, which sets out the criteria necessary to qualify for such a designation. Section 3.1 sets out two classes of people who are named in the policy who qualify as insured persons, as follows. 1. Named insurers who are actually involved in the accident. And 2. Named insurers who are not actually involved in the accident, but who suffer a psychological and emotional or mental injury as a result of the fact that their family member was involved in the accident. The applicant, Mr. Ciasulo, falls within the second class of insured persons. He is named in the policy. He was not directly involved in the accident, but he suffered a psychological and emotional or mental injury as a result of the fact that his wife and children passed away as a direct result of the accident. Section 45.1 confers upon an insured person the right to seek a catastrophic impairment designation. It reads as follows, quote, "An insured person who sustains an impairment as a result of an accident may apply to the insurer for a determination of whether the impairment is a catastrophic impairment," end quote. Pursuant to this section, Mr. Ciasulo, an insured person, applied to Unica Insurance, Inc. for determination as to whether his impairment was a catastrophic impairment. Section 3.11, again, sets out the criteria necessary to qualify for a catastrophic impairment designation. So how do we interpret these three provisions of the SABs? In the 2018 case Skunk and Katash, the Court of Appeal for Ontario stated the following at paragraph 8, quote, "The principles of statutory interpretation require that the court first look to the plain meaning of the statute. If the words have a plain meaning and give rise to no ambiguity, then the court should give effect to those words," end quote. In the 2019 case Canada, Minister of Citizenship and Immigration, and Vavilov, the Supreme Court of Canada reiterated that statutory interpretation requires reading the language chosen by the legislature in its entire relevant context. So further to these aforementioned cases, when reading the language of Section 3.11 in the entire relevant context of the SABs, including the express language in Section 45.1 that insured persons are entitled to apply for a catastrophic impairment designation, Adjudicator Kate Greaves found that the applicant, Mr. Ciasulo, is not barred from applying for a catastrophic impairment designation. The adjudicator also found that the plain meaning of Section 45.1 of the SABs contains no language that would restrict the person for applying for a catastrophic impairment designation. Furthermore, to the extent that there is an inconsistency between the language in Section 3.11 and Section 45.1, the adjudicator found that it should be read in favor of the insured, Mr. Ciasulo, and construed contra preferentum against the insurer. Further to the 2010 case, Progressive Homes Limited, Lombard General Insurance Company of Canada, which turned on the issue of insurance policy interpretation, the Supreme Court of Canada noted that one corollary of the contra preferentum rule is that coverage provisions such as Section 45.1 and Section 3.11 are interpreted broadly and exclusion clauses narrowly. Furthermore, in the 1998 case Rizzo and Rizzo Shoes Limited, the Supreme Court of Canada noted that when dealing with benefits conferring legislation, it is appropriate to utilize a broad and generous approach to interpreting the words of a section and grasp a better understanding of the words via an examination of the entire context of the section and the legislation. It is well established that the SABs is a remedial and benefits conferring legislation, and as such, its provisions, such as Section 45.1 and Section 3.11, are to be interpreted broadly in favor of the insured. This is consistent with the 2002 case Smith and Cooperators General Insurance Company, where the Supreme Court of Canada noted that the SABs is a remedial and consumer protection legislation and ought to be read, interpreted, and applied in such a manner. Lastly, in a case entitled Temec and Economical, the Court of Appeal for Ontario confirmed that, quote, "The legislature's definition of catastrophic impairment is intended to foster fairness for victims of motor vehicle collisions by ensuring that accident victims with the most health needs have access to expanded medical and rehabilitation benefits. That definition is meant to be remedial and inclusive, not restrictive, end quote. And that the goal of the SABs, quote, is to reduce the economic dislocation and hardship of motor vehicle accident victims, and as such, assumes an importance which is both pressing and substantial, end quote. In light of the aforementioned case law, the adjudicator concluded that the interpretation adopted by the respondent was restrictive instead of being remedial and inclusive. Instead of fostering fairness for people with the most health needs, the interpretation adopted by the respondent increases their suffering and economic hardship. So it's important to note that the insurer, Unica Insurance Inc., can request that the LAT reconsider its original decision. Even if the LAT denies their request for reconsideration, the insurer can still appeal the LAT's decision to the divisional court, most likely on a question of law alone, where the question would be one of statutory interpretation and the applicable standard of review would be correctness. So we'll have to patiently wait and see how this ultimately plays out to get a better sense of the legislative landscape going forward. If you want to learn more about the criteria that you must satisfy in order to obtain a catastrophic impairment designation for a mental and behavioral disorder you sustained as a result of a motor vehicle accident in Ontario on or after June 1st, 2016, then please watch episode 1 of season 2 of my vlog called Catastrophic Impairment, Mental and Behavioral Disorder. I hope you found this information valuable. If you want more information, then please read my blog called On or After June 1st, 2016. Can a person not involved in an accident meet the criteria for a catastrophic impairment designation? In my blog, I take a deep dive into this novel issue about whether or not an insured person not involved in an accident on or after June 1st, 2016 can apply for a determination of a catastrophic impairment. I also provide links to other blogs such as what is a catastrophic impairment and how does a guideline impact the determination of a catastrophic impairment, which provide additional information that you'll find helpful. My website is your one-stop source for answers to all of your legal questions concerning tort law, personal injury law, and catastrophic impairment law. If you want to book a free consultation with me, then please visit my webpage at RudderLawGroup.ca and click on the free consultation button at the top of the page. Let us be your rudder that steers your legal ship in the right direction. Please subscribe to my YouTube channel and click the like button if you found the content valuable. There you'll also find other vlogs with valuable content on tort law, personal injury law, and catastrophic impairment law. Thank you, and I'll see you soon in the 7th episode of season 2 of Personal Injury Lawyer Tips, where I'll bring you more useful legal information.